per shot. We knew that if at some point, or when at some those were no longer given to us, we were going to need to be able to show that this was an effective form of treatment. So part of the money went into, and continues to go into, a research project that we're doing with UAA's research group over there, so that we can see what kind of effect getting a shot of Vivitrol before release is having on our offenders on recidivism, clinical relapse, and also the mortality rate. So we're hope to have numbers on that later this year. The recidivism reduction funds have also gone into purchasing kind of the gold standard for assessment software. It is something that is validated by SAMHSA and is hopefully going to go online here at the end of this summer, but it will streamline our assessment process. It will standardize it across our system, and it's our hope that community providers will also begin using that software so that we can reduce the time that folks need to, from the time they leave corrections. There's oftentimes long wait lists for assessments, and so we're hoping that that will have an impact on that. But within our system, we expect to be able to really streamline and standardize the assessments that we provide. The funding also went into some case management work, quite a bit of case management work actually for our folks with substance abuse issues transitioning back into the community. We also added a couple of peer-based programs. So there's an Alternatives to Violence program that we have added in a couple of our facilities, and also a WRAP program, a Wellness Recovery Action Plan program, in several of our facilities. We are hoping to expand both of those programs coming up this next fiscal year. And then True North Recovery comes in also and does some peer-based services. They bring in speakers. They provide case management to our folks. We also started providing Narcan. Narcan is now available inside all of our facilities for not just our medical staff, but all of our officers have been trained in the use of Narcan. It's also, these funds have also allowed us to provide that to all of our field probation offices, so that our probation officers, especially when they're out, doing home visits and such, they are trained and prepared to use Narcan if necessary. We have started a pilot program to provide Narcan to offenders as they release from our facilities. No questions asked. Here's a Narcan kit, whether that's for you, a family member, a loved one, whatever it might be. We will provide, right now we are just doing that out of our Anchorage Correctional Complex, but it seems to be gaining momentum, and so we're hoping to expand that, the distribution of Narcan to anyone who leaves our facilities. We're hoping to expand that statewide this coming year. We have a number of other programs that we're kind of working on, and we're hoping to expand some of the existing programs. But that is it in the nutshell for the institutions. We have a number of projects that we put in place for our folks in our halfway houses. Primarily what we've had to do with that population is provide treatment slots in the community for intensive outpatient treatment. And so a good portion of the marijuana tax recidivism reduction funds have gone into our various communities where there are halfway houses, so that our individuals who have substance use issues in our halfway houses can immediately access intensive outpatient treatment when they're returning to the community. So that is it in a quick overview. Like I said, we are working. We're actually meeting again this afternoon to talk about how we can further expand our treatment availability and our support services for this population. But if anybody has any questions about what I just ran through very quickly, and I know I spoke very fast, I am happy to answer any questions you might have.
Yeah, do we have any questions for Ms. Brooks? I got a couple. $1,000 a shot for Vivitrol, and that's like that's almost getting the price of insulin. Is that covered? I know there was some discussion during Medicaid expansion a couple of years ago that there would be the potential that Medicaid expansion would bring additional services to DOC clients. Does Medicaid, whether it's available now or not, cover Vivitrol?
So Medicaid expansion, really the way it primarily affected DOC was for folks who are still incarcerated. If they go to a hospital, that treatment, that hospitalization was now covered by Medicaid. In terms of the community, it really depends. I don't have good numbers for that. There may be somebody else online who has better information for that than I do. But what we have done with some of these folks is we have paid for, like, say, their initial visit, because even if they are eligible for Medicaid, sometimes, you know, if they're in custody for more than 30 calendar days, that their Medicaid is suspended, and it takes some time to get those benefits restarted once they hit the community again. And so we have provided some funding for that initial visit and that shot after they've been released in that first 30 days, or that first shot after the 30 days that they've been out. But my understanding is Medicaid will provide coverage for some of those visits and the shots as well.
Okay. Is there in-institution use of Vivitrol? What is that, a monthly shot, or how often how often does the injection got to be given?
Sure. So we provide it as the individuals are getting ready to release. So anybody who is 60 days from release can be referred for a Vivitrol shot. They go through a medical screening to make sure there's no contraindications for its use. And then we do what's called a challenge to make sure that they actually handle it well. So they take an oral dose of it. And then usually about 2 to 3 days before their actual release, they will get their shot. And then they are given recommendations for treatment providers in the community who also provide Vivitrol shots. And we are trying to increase the case management, the in-reach, as it's called, for those individuals to make sure they get to that first appointment. But the first shot is given in custody, and then the subsequent shots are monthly after that in the community.
Okay, wonderful. And the Vivitrol and the things you talked about are either paid for or supplemented. Their costs are supplemented by the recidivism fund.
The in-custody process is for sure, and one of the big primary areas where that funding goes is actually to a substance abuse counselor who works with those individuals once they're identified in custody as a potential patrol program participant, gets them through that process in custody, and then provides them with the referrals for the community and tries to get them that warm handoff as they're leaving our institution.
Okay, real good. I hope you'll be able to get something going with Vivitrol in Bethlehem. You're either working with YK or with the family clinic, I guess, on medical supervision for that.
Yep.
And so just a couple observations for you and for Ms. Wooden. I know when you were talking about helping folks as they get out. If you want to give them a fancy title, call them freedom navigators. Right? I mean, you're helping somebody get a birth certificate and get a state ID, and sometimes you literally, and having done it before, you literally got to hold their hand. So,
absolutely.
I just want to say, I really appreciate your presentation, Ms. Brooks, and I have to say that between these two ladies here and our staff, if that doesn't give everybody here and listening a new and fine appreciation for the employees the state of Alaska has, it should. So thank you, Ms. Brooks. I appreciate your time, and we're glad that you're all being able to do good work with this money that you're getting. We're going to hear about the tax program in a minute, but just remember that really the taxes that are getting paid in the cannabis industry ends up being Alaskans helping Alaskans. So, all right, well, thank you very much.
Yes, thank you for having me.
All right.
The conference is now in listen-only mode.
We're going to give a well-deserved half hour to Ms. Milks, our learned counsel since the beginning, who has, in some cases, held our hands, collectively and individually. She is going to just do kind of a retrospective on the history of regulation in Alaska. We asked for this for the benefit both of Mr. Jaime and our mystery, not member here yet. So you'll probably be doing this again in Nome, Harriet. Maybe not.
Okay, thank you.
So you have the floor.
Okay, I'm going to see if I can drop the lights a little bit so these slides are a little clearer.
Oh, and while she's taking a break, at some point before lunch, we'll probably accept a change the agenda. The licensee for tab 22 is jetting out this evening. We may or may not get to there on the agenda as it is. It's an appeal, so I'd like to be able to facilitate that sometime before quitting time.
It's 23.
20, oh, it's 23?
2022.
Oh, yeah, let me... Okay, that's Mr. Happy. Oh, I see, yeah, okay, it's not... It is an appeal, right? Okay, all right. So we will get to it.
Light switch on the back wall. Not all, just a few of them. But now you can all see why I'm for council and not Well, I get set up. I just want to thank. Whoa, wrong one.
Hey.
I want to thank the Fairbanks North Star Borough for these facilities and Jessica in particular, because this allows the public to participate in my remarks, and the public really is the reason we're all here today. It's the focus of the board's work, and glad we're all here. The relationship between Alaska's law and marijuana goes back a long time. Goes back before 1975. But in 1975, personal use became legal in Alaska. In a case called Basin, the Alaska Supreme Court held that the Alaska Constitution gives every Alaskan the right to maintain in their home and use small amounts of marijuana. In 1998, Alaska enacted the medical marijuana statute, and it's a really limited statute. What it does is it gives individuals with certain statutorily enumerated debilitating conditions the right to speak with their physician about how marijuana might assist them, and it gives the physicians the right to talk to them about marijuana, and it allows those individuals to possess marijuana for medical use and to grow some marijuana for medical use. But it doesn't provide a way for them to buy marijuana, and it didn't provide any mechanism for marijuana to be grown on any kind of a large scale. The law flip-flop back and forth with respect to criminal vulnerability for individuals using and possessing marijuana for a number of years. And then in 2014, Alaskans did something pretty unique. There are two ways to make law in Alaska. One is the way that we're seeing happen right now, which is the legislature enacts laws. They draft laws and enact them. The other is by a citizens' initiative. And in that process, which is actually sort of a difficult process, is there's a lengthy certification program, but the Alaskan people themselves drafted this law, and they put it on the ballot. The process is called the ballot initiative, and that's the law that became our Alaska marijuana law. It passed, but not by a huge margin. 53.23% of the vote voted for. But almost 47% of Alaskans who voted against it. And that's important because 131,000 Alaskans, some who may be here now, certainly some of our family members, friends, business associates voted against creating this new marijuana industry. And those are the people for whom the board works as well, and that's very important to remember. The medical marijuana statute is still in place. The protections of Raven versus State are still in place. But the new law, which became effective on February 24th, 2015, clarified the personal use law that was set out in Raven versus State. It had no effect on the medical marijuana statute, and it provided for a legal industry and for the production and sale of marijuana. The initiative contains a very clear and unambiguous statement of purpose and finding. Not all Alaska statutes do. This one does. Very important because it serves as guideposts to the board. And the purposes that are stated unambiguously in this law are that legitimate tax-paying business people and not criminal actors will conduct sales of marijuana. Marijuana will be sold by regulated businesses, and it will be labeled and regulated to ensure that consumers are informed and protected. The law also provides for 4 types of licensed facilities: cultivation facilities, production facilities, retail stores, and testing. It allowed the legislature to create a marijuana control board. Initially, these regulations were overseen by the Alcoholic Beverage Control Board, but subsequently the legislature created the Marijuana Control Board. The initiative also provided for local control and for no public consumption. Meanwhile, the federal law is pretty much, as the graphic there shows you, all forms of marijuana remain, except for industrial hemp, remain on Schedule 1 of the Controlled Substances Act. Industrial hemp was taken out of the Controlled Substances Act in 2018 by the Farm Bill. In 2013, the federal government issued the only really specific guidance for states that were enacting laws decriminalizing marijuana and providing for a marijuana industry. And in that memorandum, the U.S. Department of Justice said essentially to the states that were regulating marijuana, okay, we see you, we know what you're doing, we're not a fan of what the federal government was calling experimenting with these marijuana programs, but if you're going to do it, you must do it with a robust regulatory scheme. And this board has adopted the Cole Memorandum as its enforcement priority. Now, the Cole Memorandum was rescinded in 2018, but there hasn't been any subsequent development or any subsequent specific guidance from the federal government. The Cole Memorandum, in addition to instructing states to enact robust regulatory schemes, set out 8 enforcement priorities. And as I just mentioned, those enforcement priorities have been adopted by this board as policy. And they are to prevent marijuana from falling into the hands of minors, to keep revenue from coming from or going to criminal gangs, to prevent diversion from states where marijuana is legal to states where it's not, to prevent state-regulated businesses from being a cover for illegal activity, preventing violence and the use of firearms in cultivation and distribution of marijuana, preventing drugged or impaired driving or other adverse health impacts, and preventing growing on public land and federal property. The Citizens Initiative required the Marijuana Control Board to enact regulations, and they did. The initiative gave the Marijuana Control Board 9 months to enact a comprehensive set of regulations. It's a huge job. And the takeaway from this slide is that the Marijuana Control Board worked very, very hard over this period of 9 months to develop what ended up being 132 pages of regulations with a lot of public input. A couple of dates are significant here. One is September 2015, the Marijuana Control Board put the entire set of regulations out for public comment. By that time, the regulations had gone out in chunks twice before. So each of the regulations had first comprehensive set that the board adopted went out for public comment from people like you for 2 30-day sessions and 1 45-day session. In October of 2015, the board sat and heard 2 days of nothing but public testimony. That was in Anchorage. It was also video conference at 13 locations around the state. In November, the public comment period closed, and the board received over 5,000 comments. Later in December, the Marijuana Control Board met and adopted that comprehensive set of regulations with 2 days to spare. And just like that, we're open for business. The scope of the regulation is huge. It includes, the regulations cover 8 articles, covering who can get a license, where you can have a store, how you apply for a license, how to transfer, what happens if one of your partners dies, C, packaging, labeling, public participation, requirements for licensed facilities, product testing, provisions for on-site consumption, civil penalties, enforcement, and of course, we'll hear more about this, taxes. The marijuana taxes marijuana right now is taxed at a flat rate of $50 per ounce for bud and flower, less for other parts of it. But here's the takeaway. In 2018, marijuana taxes brought into the state just a hair under $12 million. That's in 2018. I don't have the figures for this year. There are 2 features of the regulations around which really the whole program is built. One of them is the seed-to-sale tracking system that we heard a little bit about in public comment. In Alaska, we use the metric system. Cultivators are required to tag their plants to reach a height of 8 inches with RFID, that's radio frequency identification tags. Those tags identify the licensee, the plant, and other information. And this information travels with that marijuana from the time that you see there on the screen until the marijuana leaves a licensed retail facility with a consumer. And this system serves the initiative's very clearly stated purpose of ensuring that the industry is run by legitimate tax-paying business people and not criminals, so we know where the marijuana is grown, where it comes from. Schemes like you see on the slide prevent black market marijuana, or supposed to, and for the most part, do prevent black market marijuana from entering into the cultivation facility. And because we know when the plants are grown, how much they weigh, what the production is, we know that all the plants that leave a licensed facility are legitimate, lawfully, legally produced marijuana, so we're not contributing to the black market. And secondly, this tracking system ensures that the public is protected and informed about what they put into and onto their bodies. The second part of the second feature, which really sort of controls these regulations, is that Alaska, it's a public process. So Alaska law, and specifically the Administrative Procedure Act, requires that the public be given notice of meetings, that's why you're all here, and notice of all proposed regulations and amendments to regulations. And the Administrative Procedure Act also requires that everybody has a meaningful opportunity to comment on proposed regulations, and it requires the board to take those comments into consideration before it adopts regulations. This allows the board to implement the statute, again, going back to the stated statutory purposes, implement the statute to serve the people, and it ensures that the regulations will evolve as the people's needs change. Not just the industry's needs, but as the people's needs change. This is a picture of the very first Marijuana Control Board meeting. Some of those characters I see here in the room today.
Up here.
Marijuana Control Board is a quasi-judicial agency housed in the Department of Commerce. What that means is that the Department of Commerce provides critical administrative assistance to the board. HR services, materials, office space, things like that, but it does not play a role in the substantive work of the board. All of these Marijuana Control Board members that you see up here are volunteers. They receive a per diem, but they are not paid salary. They share staff and a director with the ABC board. They meet at the same time and place as the ABC board, and they have to meet at least once a year in each of the 4 judicial districts. And the reason that's statutorily required, and the reason for that is because the people, in the case of the Citizens Initiative, wanted to make sure that the Marijuana Control Board met to study the statutes and the regulations in light of statewide and local issues. We heard a public comment earlier, and something that we're all very familiar with, that Alaska presents a lot of special challenges because of its diversity and because of its geography. These meetings are, as we all know, not limited to one-day meetings. Lately, they've been 3-day meetings. This is to accommodate the industry as it's grown. In 2018, the Marijuana Control Board met for a total of 8 days. It's a lot of time. Board's powers and duties are statutorily defined. They propose, adopt, and amend regulations. They approve licenses and products, and they adjudicate disputes. The director is appointed by the governor. She works for the Marijuana Control Board and the ABC Board. The director maintains an office of about 21 people, including 5 license examiners, a regulations specialist, a local government specialist, administrative assistants, and 9 enforcement officers. And I'm sure she'll correct me if I'm not up to date on my figures. Is that about
8?
Right,
8 enforcement officers.
8 enforcement officers. It's a big staff, and although this board makes it look easy, there's a huge amount of work that goes into preparation for these meetings. You can't see it in public and folks listening at home, but each of the board members has a computer that's loaded with what we call a board packet. Board packet contains all the documentation for the applications that are before the board for this meeting. Typically, Marijuana Control Board packets are 800 to 1,000 pages long. And for those of you, and I recognize a number of very familiar faces, we all know that the board members read those pages. It's a tremendous time commitment for the board members, and the job that the director has to pack it together is remarkable, really. One of the important functions of the board is to engage in what we call administrative adjudication. And what that means is, inevitably, in the course of regulating in the industry, disputes are going to arise relating to compliance with the statute and regulation. The board's regulations provide procedures to address those disputes and to protect the due process rights of licensees and of people who are not licensees. There are a number of processes that are set out in the regulations for conducting administrative adjudication. Board holds hearings to hear disputes, to make decisions. The Office of Administrative Hearings also conducts evidentiary hearings at the request of the board. And one of the really highly functional, important aspects of these protections in these regulations is an informal conference. An informal conference, which is provided for in the regulations, allows a licensee who's been aggrieved by something the director or the board has done, or some decision that they've imposed on them. It allows that individual to go before the director or the board before things get too crazy for an informal conference to talk about where the board or the director thinks that the individual has strayed from the regulation. What the individual to come back into the fold. The board works and the director works very, very hard to keep licensees operating within the bounds of the statute and the regulations and in keeping with the stated purposes of the initiative, that is to keep people safe, to keep businesses running. Since the board has been formed, 14 cases have not been resolved in those informal conferences. They've proceeded to evidentiary hearings before the Office of Administrative Hearings. 4 of those cases settled. In 4 cases, the licensee or the litigant withdrew their appeal. And 6 board decisions that went all the way through the process of an administrative hearing resulted in a decision by the administrative law judge supporting what the decision that the board had made previously. This chart is a little hard to read, but I'll explain. I think it's actually more impressive if you can't read it. The big blue circle represents all of the calls that the board's enforcement team received in the first quarter of 2019. 4,000 something calls, emails. The green slices of the pie to the right represent the enforcement team's work with marijuana. The red is, for the most part, alcohol. During this period, the board's enforcement team issued about 50 notices of violation and advisory notices. The statute provides that the director and enforcement officers may, with the concurrence of the Commissioner of Public Safety, exercise peace officer powers granted by the board and when necessary for the enforcement of the criminally punishable law. So these enforcement officers act to ensure that licensees are in compliance with the law, or as part of what they do. And the law is also applicable to non-licensees because the statute provides that there's no, for example, there's no public consumption. And these peace officers also work to address situations that are presented by the still existing, although quite diminished, black market in Alaska. The board is governed really by 2 guiding principles. One is the Open Meetings Act, and I think honestly, I reprinted this here because I think people can't read this often enough. This board, like all boards, public officials, they work for the people. They work for the public. The Open Meetings Act states that it's the intent of the law that actions of government bodies be taken openly and that their deliberations be conducted openly. The people's right to remain informed shall be protected so that they may retain control over the instruments they have created. What that boils down to in terms of this board's function is that the board acts only as a body. These individual board members have no authority to make any decisions on their own. That's why regulations must be noted publicly and adopted publicly and debated publicly, and that's why notices are given for all of these public meetings, and also why the law requires the board to consider public comment, because they don't act alone. The second guiding principle is the Executive Branch Ethics Act. You heard me mention that earlier. Basically, service on a board is a matter of public trust. And the Executive Branch Ethics Act applies to all board members and all public officers. It requires you, members of the board, to disclose any relationship, I heard this earlier in the meeting, any relationships, employments, or other circumstances that could create a conflict of interest. And what the Act talks about really is a substantial conflict of interest. The Act anticipates that you will bring to board service your own life, your own experiences, your expertise. The law doesn't expect you to hang your life on a hook on the door as you walk in, but you are expected to bring your public service first, and that means don't take any actions that you would take as a board member. Don't engage in those actions specifically to benefit a personal friend or a family member or a business associate. Conflict of interest issues often arise, as I suggested earlier, in the context of communications that you have with members, public members, industry members, really anyone outside the board. Contact outside of a public meeting by a person who stands to gain or lose because some action or takes should be strictly avoided. And this happens frequently. People will come up to you on the street. I know it's happened to probably all of you board members, and say, and people will say, hey, my friend has an application before you. I hope you like what they said. And usually there is. Use that as an opportunity to invite those individuals to come to part of the public process. Again, the public is really driving all of this. Finally, the role of board counsel. Why am I here? The Department of Law provides counsel to the Marijuana Control Board. We provide assistance and advice on a day-to-day basis. Lots and lots of things come up on it. Every day there's a new question. We provide advice on issues relating to board governance, and specifically compliance with the Administrative Procedure Act that I mentioned earlier. A lot of what board counsel does, a lot of the hours that I put in are involved in assisting the board with regulations. The board counsel doesn't have a role in constructing the policy of the board or telling the board what regulations they need. That comes from all of you sitting in this room and from the rest of the public. You communicate that need for new regulations or amendments to regulations to the board. They deliberate it. I assist them with writing it. I assist them with making sure that the regulations adhere to certain constrictions of form. I make sure that the regulations are noted consistently with the Administrative Procedure Act, and again, I assist with drafting the form of the language, never with policy development. And once the board adopts a regulation or an amendment to regulation, the Department of Law conducts a very close analysis of the language that the board has adopted to make sure that it's constitutional, that it's consistent with the other regulations that the board has adopted, and that it adheres to form. Board counsel also assists the board with administrative litigation. When cases go to the Office of Administrative Hearings, as I mentioned a second ago, board counsel represents the director and the staff in those matters. When they come back to the board from the Office of Administrative Hearings, the board is the decision maker. You all are the decider. Board counsel has represented the staff. Ultimately, the decision in any administrative adjudication rests with the board. So that's a very quick overview about why we're all here, how we got here, and the purposes and principles that guide the board's work. If you have any questions, I'll be happy to try and answer them.
Anybody got any questions for Ms. Milks? I think you talked a little bit about our interaction with OAH. We will talk about that again the next time we have an interaction with OAH. It's kind of a unique circumstance for the board, and it's actually kind of interesting the way we deal with that. And on the Executive Branch Ethics Act, maybe I missed it, but the board has an ethics officer, but we also there's also an assistant attorney general who is available to us individually. I don't know who it is these days, but if we have questions that we would like to ask them, could you tell us who that might be and discuss how the attorney-client privilege would work between an individual board member and the ethics advisor in the department?
Sure, and thanks for that question. It does take a little consideration. Initially, and really ultimately, anything that could be a conflict of interest needs to be disclosed to the public on the record. So if any of you has, again, a change in your business relationships, or you've had a communication with someone outside of the board about something that you have the ability to decide, that needs to be disclosed on the record at a public meeting to you, Mr. Chair. You are the board's ethics supervisor. And in that instance, you make the decision whether there is a conflict of interest. If the conflict involves the chair, then it goes to the governor's office. There's another individual who is appointed to do that. Now, in the meantime, if one of you has a circumstance that you're wondering, gee, whether I should disclose it, you can call the Assistant Attorney General who is assigned to address ethics issues, and in that case, attorney-client privilege applies. That individual right now is Maria Barr in my office. She doesn't get too many calls, but again, just as I introduced the Citizens Initiative, the purpose is you're here to serve the people. And so to the extent possible, anything that you think could create a conflict needs to be shared with the people. So I would not encourage any board member to keep these kinds of things just to themselves and try to work it out with an attorney. That's available to you, but it should not at all substitute for public disclosure. So if you do have one of those circumstances, it's an option, but those contacts need to be disclosed on the record.
Yeah, and I wasn't suggesting that the receipt. I mean, I just wanted to make it clear that there is professional ethics advice available to us as individual board members, as is available to all board members in the state, I believe. But yeah, that does not. Basically, the question would be, this could happen, or if this happened, or would it be okay for this to happen? And in any event, it would be disclosable. Just to know that we, as individual board members, have some counsel that would probably be, the answer would be, well, disclose it to the ethics supervisor. But just to know that we have that there, and that and actually, Harriet can offer us, if any of you have any questions, never be afraid to pull her off in the corner and talk to her.
Well, and that's another good point, Mr. Chair, because I don't work alone. I have the resources, the tremendous resources of the Department of Law behind me. And when one of you asks a question involving a potential conflict of interest, very often I will contact the ethics attorney in my office and say, hey, what do you think about this? And is there a conflict? And where do you see the conflict? Because the Ethics Act doesn't recognize everything as a conflict. It talks about substantial material conflict, and it usually involves money. So well, you can figure that out. If you have a company that could benefit, or your job benefits somehow, that's really what the Ethics Act addresses. But there are as many permutations of conflict circumstances as there are individual people. And so if I become aware of something that could potentially be a conflict, I usually run it by the ethics attorney. And that also, it's good for the public to know, too, when there is a difficult issue or a complex issue of statutory interpretation. I very often run that through my more senior colleagues at the Department of Law in the regulations section for confirmation as well. So we have your back.
Mr. Chair?
Yes, ma'am.
May I ask a question?
Sure, go ahead.
Harriet, is it accurate that you talked about the chair being the ethics supervisor for the board, and so that when a board member discloses a conflict, the chair will make a ruling on that conflict? Is it also true, and I'm sure this will never be needed, but is it also true that the board can override the chair's determination on a conflict?
Absolutely.
Yes. Just wanted to make that clear. Again, probably not needed.
I think that's in Robert's rules, I think.
That's a great reminder also of how this board acts as a body and not an individual. The chairman of the board doesn't get to make decisions by himself about, I'm sorry, Mr. Chair, about anything really, including this. You do make the initial call, but
I do for breaks.
Yes, for breaks. But any member of the board can request the board to vote on that and can override it. Great question. Thank you, Director.
All right. Cool. I think you summed everything up in a very big nutshell. That was an excellent presentation. Thank you. And I think we Need to have something similar to this every couple of years. Okay, so exercising my authority to make only one decision on my own. Let's break till about 10:30, and we'll come back for Ms. Wilsina's presentation. Oh, great. I'm gonna give you credit.
All right.
But just, actually, I can't see. I wasn't even sure. So actually, you're okay. You don't really notice.
Well, I kind of only
You got a bottle of water here? You got a bottle of water? Okay.
Yeah.
All right. Okay.
Yeah.
Good.
My eye drops for my eye
Yeah.
infection. I got my cough medicine.
Yep.
It's like a big medical bag right now.
If you want to take a nap, go ahead.
Oh, great.
We'll wait for the important stuff.
All over the table.
Yeah.
Very good. Right? That's the nature of it, yeah. Yeah, cool. All right.
Yeah, the other day I was in like
It was a short course. Long course.
bonus, thank you. So I do have a question.
Yeah.
I'm not asking questions, because I've been work fire addressing in the past. Like the DOC, they have a committee put together to determine where their facilities and funds go, or who's in charge of that?
No, good question.
No,
No, that's not something the board has authority over.
no, it's true, but,
Yeah.
but we're not giving that authority to, but they're receiving funds from,
From the taxes, and
Yes.
but that's managed through the Department of Revenue.
is it? Okay.
Yeah, so it's not quite you. Although this board used to be in the Department of Revenue. Boards have to be housed somewhere.
I was kind of, curious about the accountability of where this money goes.
Yeah. That's the Department of Revenue. I can find out. It's a good question.
I was just curious, it's not a big deal.
I'll call my colleague who works with them and
Not a big deal at all. One more question for you.
yeah.
The notes we're taking, are those collected at the end for any reason, or they are notes solely for us?
If you're taking notes during this meeting, it's solely for you. What I do, and you know, I keep the agenda and I write notes on the agenda, and I keep them for a certain period of time because, believe it or not, a lot of these issues come back over and over again, and you'll start to think, oh, wait a minute, did we?
Mm-hmm. And that's why I asked a question about the committee with DOC, because, yeah, I know it was addressed in the past, and I'm not going to say that you get time about it. The one thing I didn't get was the attorney that spoke, the second female.
Mm-hmm.
What was her name?
Brooks? I think she was Laura Brooks.
No, that was DOC.
It was DOC. Oh. We
The one
had-
that brought the question
Oh.
about the 5,400 milligrams.
Oh, Jana. Jana Weltdin. Weltdin.
W.
Eltdin. She's going to make a presentation about, she's got some tax issue, Jana
Oh,
Weltdin.
same one? Okay.
Yeah.
No, because that was a good point that she brought up. Anything, if there needs to be clarification for some of the regulations,
Yeah.
I think that needs to be discussed.
Oh, absolutely. Regulations process, these regulations are evolving. I could talk for hours about this. They're evolving. One of my colleagues in Colorado said, you know what, it's kind of like building a technology plane. Things come in every day I get questions in, and they're new things. But the regulations process is long and cumbersome and expensive. And so the director tries to collect them and I work with her to draft language for regulations, so that they go
So when the public brings up a concern, like, entities, you guys note that, and then
Yep.
rewrite it, or whatever, if you think it needs to be, you guys rewrite it?
Well, I don't make those decisions. That's what happens there is you have to tell the director, we want you to turn that into a regulation.
Okay.
Or what you can also do is you can say, hey, we want to look at that issue more carefully, so let's form a working group. Let's have one of you work with the director. And you can't do three of you because then it's an exact issue, but have one or two of you work by yourselves, or one of you work with the director, and gather information and see what you can really do about that and then draft a resolution.
It's just because you mentioned it, doesn't mean it's,
Right.
you know, I think you should.
Right. So if you think you should have them, you should say, Mr. Chair, I'd like to talk about forming a working group to look at this issue and maybe draft a regulation. I volunteer to be that working group. Let's say, great. Then you do that. You write something up. You work with the director. It sounds, in this particular case, I think realized that it sounds in this particular case, like we should probably wait to hear from the enforcement officer and more information about it.
Oh, yeah, I'd agree.
Maybe, no, and maybe work with the family director. That's a good point.
It is.
And one of the fascinating things about this board is every meeting, something will come up and you'll think, I didn't think of that. It's very exciting.
And there's actually an enforcement issue, because if you go by the run of the law, you know, it's defined in A of the sentence, and then subsection C, it contradicts A. So, I'm just, not huge, but it does.
Yeah.
There could be a violation,
Yeah, they could be.
depending on who interprets it.
Yep. Yeah, don't hesitate to ask questions like that. Well, I know that probably offended your sense of how PowerPoint should not be any more than 9 slides, but I just couldn't do it.
I hear you. Do you get involved early on and feel that the reason I ask is that there's got information, Erica, related to rainforest selling, or, you know, had sold without telling us?
It was a last time.
I don't think it was on the last time. I think it happened after the last time. It sounded like she was going to schedule a hearing, and I'm not heard. So.
Yeah, I think it's safe to assume that I'm consulted on all of my actions. I don't know what the status is, you should talk to her.
Okay, well, she was here, that's why I thought you could do it on my brain.
Yeah, she was out for 2 weeks ago, and that's why I wanted to see preliminary discussion. It sort of collapsed. Yeah.
Okay, why has my phone been vibrating so much since I turned it back on? Pray tell. People excited about that? I doubt that. I doubt that. I got any lights on here. So how was the academy?
Where it was? Oh, that was interesting. It was 3 months. And after 20 years being out of college.
I don't understand.
Yeah, there you go, there you go.
A lot of
reading. Well, sure. And it just, wasn't what I expected. Yeah, it was all classroom, and it was interesting, very informative. I learned a lot, so it was,
There's no reason.
hopefully just take the benefit from the training.
Yeah. But it was something I feel.
It's a long time to be gone.
Yeah.
Oh,
How long was it?
3 months.
3 months, I was
There
curious.
was a break in the middle,
Whatever.
but, you know, flying up to Alaska, it's a huge travel break, yeah. So I stayed down there with my family.
What part of Kentucky?
Louisville.
I've been to Lexington.
There was some.
Okay, yeah, never in Louisville. Louisville is actually a big city.
Kentucky's kind of an interesting place. I went down there I went through a Rural List, Local Initiative Support Corporation, conference years ago. And, they're kind of a finance type of operation.
Fabric.
Janice set up for her thing.
So how does that compare, talking to people that have been there and have, how does that compare with that?
They get to shoot machine guns at the National Academy.
Well, no, you know, the SPI is what it's called, is, you know, it's books. Learn more, you learn more. What they say is, if you want to learn, you go to SPI. If you want to network, you go to SPI.
There you go, there you go. Okay, cool. Are you all set? Are you plugged in, Jenna? Oh, you are? Okay. Sounds good. Okay, well. Yes, we do. Yes, we do. Okay. Yeah, you should lights on, yeah. Or is everybody good with the lights the way they are, or do you want it back on? I think I'm good, I can see.
I'm a sunshine boy.
We could turn them on.
Anybody want a hard copy?
Yeah, well, you're only one member. Oh.
You're kind of in the dark spot, though.
Okay, no, go ahead. Brandon's got shade.
Didn't I just talk about how everything has to be done in the open, in the sunshine, light of day?
You didn't say nothing about sunshine.
Well, I guess I missed that one. Light of, yeah, the sunshine, maybe not, the light of...
Okay, the phone, I believe the phone is back on, because I keep hearing it.
Phone number went off.
Okay, all right, well, good thing we didn't say nothing. Interesting. Quit dating yourself. All right, so it's 10:30. We are a couple after 10:30. We're back in order, and we are now up to agenda item tab 2. That is 10:30. And Ms. Weltzine, the other learned counsel in the room, will make a and this is at her request to make this presentation. It's going to be about taxation, which, for the benefit of everybody, the board has absolutely positively no authority over. However, taxation has a significant effect on the state, as we heard from some of the recipients, and it also has an effect on the largest taxpayer, who is our cultivators. And so with that, Ms. Wilson.
Thank you very much. General Wilson, for the record. This presentation was made at my request because I started getting, a lot of phone calls from my cultivator clients struggling with this inflexible tax burden. I also first want to, because I didn't in my opening public comment, thank the staff at AMCO. They've been doing a great job. Licenses are being renewed quickly. NJ 14 changes are being responded to quickly. The renewal process for my staff has been made a lot easier because AMCO staff has been really good at speaking with us, and I just want to thank them for their hard work. I know they put in a lot of extra hours. And Officer Heine, thank you for volunteering to do this service. You've got some big shoes to fill because I never thought I would say it, but every single public safety seat we've had has been awesome and been really fair and really good addition to the board. So I'm sure you're no exception to that. So I wanted to talk a little bit about the tax structure, because while the MCB has absolutely no authority or control over the statute that controls the tax structure, this board and the staff is the #1 governmental body that actually understands our industry and also the best place for a public platform to speak to the industry about the PR issues we're going to be facing soon, because we have about 1/3 of our taxpayer base not paying its taxes because it's not necessarily feasible with the business structures that we have. So I want to go first into why should we care if cannabis businesses tank? And we should care because we've seen already the incredible economic force that this industry has had in our state. The last 3 years we've been going through a recession, and our Alaska-owned, 100% Alaska-owned industry has generated thousands of jobs during a recession. That's very difficult to do, but we have done that. We've also generated millions of dollars in tax revenue, and we're one of the only industries in this state that can look the governor in the eye and look the government in the eye and say, we are taxpayers. We are legitimate taxpayers. We pay a tax to the state of Alaska, and that's not something a lot of industries can say in the state. Almost everybody in this room, if you're a consumer, a retailer, a manufacturer, a cultivator, or an ancillary service like me, we are contributing to the tax payments to the state. We're contributing to that tax base. And so we should care, because not only are cannabis businesses hiring employees for their own businesses, they're encouraging hiring for other ancillary services like architects, engineers, lawyers, CPA, payroll companies, payment processors, equipment sales, lighting, all of these things that are driving force in our economy that we wouldn't have had but for the initiative passing. So I just wanted to reiterate, this is an important industry that we need to understand, that we need to learn from our other legal states, that an inflexible tax floor is not the way to go. So I wanted to, again, reiterate, the MCB is a vital tool in educating the legislature. While you cannot change the statute, you can be an educating tool, and we need you to do that, because while you represent the people of Alaska, you're the most educated about this industry. So we're going to need your help pushing through a tax bill. We did meet several members of the Industry Association, and this presentation is not sponsored by AMIA. It's not endorsed by AMIA. It's just a JDW Council idea. I just want to make that clear. So some members of the industry and myself met with the Commission of Commerce office, and we discussed tax issues, and we discussed tax ideas, and we had a representative from the Department of Revenue there, too, to kind of help bounce ideas off of. I came up with this model, and there's other ways to do it. There's probably better ways to do it, but the conversation has to start, because if we're not paying 1/3 of our tax liability, that means the governmental entities that are sharing the revenue are going to start wondering why we're not paying that additional 1/3. And I wanted to break down the numbers so you could see the profit margins are pretty thin here, given the current structure. So if not a flat tax, then what? Alaska is the only state, the only legal state that bases its taxes solely on weight. Every other state has some other kind of combination method, whether it's a price-based excise tax, whether it's a retail general sales tax. We are the only solely based weight excise tax. So that's got to say something right there. We know if other states that have been doing it longer aren't taking this approach, we maybe need to bob and weave and adjust our approach. So I gathered some numbers from several of my clients for cultivation, just so I could give you a breakdown on what the real market is like in this legalized industry. First, let's assume that the price per pound of legal marijuana in the state is between $3,800 and $1,600, just depending on the grade. The average price then would hover around $2,800. So let's assume we're looking at a 5,000 square foot cultivation facility. If we assume that, and if they're on a monthly rotating schedule where they harvest, one room every month or 2 rooms, about 46 pounds monthly should come from this facility. So at a median wholesale price of $2,800, you have $800 times 46 pounds. That's $36,800 per month in state of Alaska excise tax liability per month for a 5,000 square foot cultivation facility. Electrical costs, assuming different veg stage hours and different flower stage hours, about $20,000, depending on where you're at, right? It'd be a little bit different from Fairbanks versus Kodiak or something. Water and gas, approximately $2,000, trash, $300. Metric costs, amortized through 12 months, $500. Security, monthly, $400. General liability insurance, really expensive, $2,000 a month. Workers' comp coverage, $600 on average. Product testing, about $2,400 on average. Employee wages and expenses for a 5,000 square foot facility, about $28,000. Internet, $200. AMCO licensing fees for standard cultivation, amortized over 12 months, $600. Growing medium and growing amendments, nutrients, obviously varies from cultivation to cultivation. I picked a number in the middle, $3,500. So the total monthly cost of production and compliance for a 5,000 square foot cultivation, roughly about $97,000. So this also, that number doesn't include things like rent, advertisement, legal fees, county fees. So just keep that in mind. So we've got a total of $97,000, and then we take the 46 pounds times the median wholesale price of $2,800, and we get revenue of $128,000. Okay, $128,000. So then we minus our production cost of $97,000. We're left with a remaining revenue of around $31,000. That's our remaining revenue. So this remaining revenue now has to cover our advertisement, our mess-ups, our rent, our legal accounting fees, cash management, modifications, MJ14s, 15s, local taxes and expenses, transportation of product costs, which is huge, and clearly $31,000 is insufficient to cover all of those expenses, especially since we can't do regular traditional credit lending or things like of that nature. So let's look at it, and let's look at a different tax structure. What would a different tax structure look like? So we're going to assume for 5,000 square feet of cultivation, they produce a monthly sales generation of $128,000 roughly, and we deduct the cost of production without the $800 an ounce excise tax. So that brings our production cost down to $60,500. And then we add a hypothetical 10% excise tax. That's based on the fair market value of $128,800, and that would be a $12,880 excise tax. So in summary, we've got the $128,800 in sales, minus the $60,000 in cost of production, minus the tax liability, the hypothetical 10% tax liability, and we end up with $65,420 less in revenue. So that's the new number less in revenue. So that can actually cover all of the additional expenses with some profit, which is what we want for entrepreneurs, because otherwise who's going to invest in this market if they're just buying this as a job? So currently, as it stands, when we look at the median price right now of $2,800, that's over 24% tax rate. And that is without question, that price, without question, is going to go down because we continue to exercise this no limit on licensing method. So that production cost, that $2,800 average price will go down because supply will go up and demand will stay the same. So if not a flat tax, then what? So I drew in part this approach from Nevada. So Nevada does a combo approach. They do 15% excise tax of the fair market value paid by the cultivator on wholesales, and then they do a 10% excise tax on the retail sales. And we first considered, I guess it was a year ago, a retail tax idea, but the Department of Revenue seemed like it was not going to be too feasible, and it seemed like the legislature wasn't something they could bite on because it takes away from the local government perceived ability to tax. So I stayed away from the retail tax. So Nevada is integrated like Alaska, meaning we can hold all three levels of licenses. So the question becomes, if you're a cultivator and a retailer, you own both those licenses, how do we protect the fair market value? How do you not sell to yourself for $50 a pound? And Nevada, and I've attached it as an attachment, has a fair market value methodology that it uses metrics so it can spot price. And then every 12 months it comes up with this fair market value. So if you're going underneath it consistently, then you're going to get a red flag. You're going to get audited, right? And if you're going, so that's something to keep in mind, that there is a safeguard for that. So there's going to be a big gap, right? If we only do a 10% cultivation tax, there's going to be a huge gap in the tax revenue for the state. So the second part of this model would be adding manufacturing as a 10% wholesale tax. So to break it down, here's the basic idea. Cultivation of retail would be a taxable event, 10% of fair market value of the cultivation product. Cultivation and manufacturing, not a taxable event. Manufacturing to retail at 10% fair market value of wholesale price. So when we break down the market, I'm going to skip the, because I'm going over my time, I'm going to skip the breakdown of the cost of production for manufacturing. And we can go back to that if you have questions. I know I only got 10 minutes, so I want to kind of hustle through. So the total Alaska marijuana retail sales was about $130 million. So if we assume that 30%, and it might not be 30% yet, but it will be 30% of that amount is retail sales of edibles, and we assume 35% of that is retail sales generated from concentrate, which is where the market will go. That's 65% of the retail sales being generated from manufacturing. The remaining 35% would be cultivation, trim, flower, joints, those kinds of things. So most retailers buy their wholesale product and mark it up 100%. So that means we need to take the $130 million, divide it by 50%. Then we have the actual wholesale value. I'm sorry, we're backtrack on that. 84 million is 65% of 130. So 84 million is our total production our total retail sales of marijuana products and marijuana concentrates. So we divide that by 50% so we can get the wholesale value, which would be about 42 million. 42 million would be about our wholesale value estimated in 2018 generated from product sales. So we add a 10% excise tax on that value, which would yield 4.24 million in 2018 for marijuana products and marijuana concentrates excise tax. Then we do the same calculation, 10% excise tax on cultivation wholesales, which would be around 45 million, and that would yield 4.47. So if we exercise this model in 2018, we would have ended up with a total excise tax of 8.71 million, which is less than the excise tax assessed in 2018 of 15 million. But as you heard Ms. Harriet speak earlier, in 2018 we only collected $12 million in tax revenue. That's because the gap is getting worse. We're collecting only 2/3 of the assessed amount that the Department of Revenue is assessing. Only 2/3 of that is being collected. So keep in mind, so if this new model in 2018 would have gotten us to 8.71 million, we collected 12 million in 2018, and currently 1/3 of cultivators are either on a payment plan or in delinquent status. So when you think about it, 1/3 or 3/3 of 15 million is right about 10 million. So for practical purposes, we're almost getting to the same result. But we're avoiding businesses going out of business, losing jobs, losing investments, losing their retirement accounts, losing their properties. So actually, it kind of seems like it would work out better for both parties, for the state and for the marijuana industry. Again, this doesn't have to be the answer. It's just to get the conversation started and to get the industry thinking. I went through the NOVs, and 21 of them were NOVs for tax delinquency. There were 38 NOVs total. So that means more than 50% of your NOVs are delinquent taxpayers. And as you see the breakdown, sometimes it's not economically possible to make all those ends meet. And so I just want to put that into perspective. And so again, this is a public relations issue. You know, we have built a really strong reputation in the state. We have a great relationship with the legislatures. We have a great relationship with local governments. But if we get tagged as the industry that doesn't fulfill its tax obligations, most of the people aren't going to understand that economically, with an inflexible price floor like we've set here with $800 a pound, it's not possible, right? It's not possible for all of us to do this. So why we strive to make the state money, the state needs to be our partner. The state needs to move and ebb and flow with the market just like we do. And so basically this is a call to action to my fellow industry members. We've got to get together. We've got to put our brains together. If not this model, then something else, and something that will work for everybody, the state and the industry. And I'm happy to answer questions.
Okay, thanks. Any questions? You're good.
I don't know so much questions, but I read through your material, and I totally understand. I would just caution you, as somebody who's been around the state a long time, that for bottom line is consumers pay the taxes. When we buy at a retail, we are paying for the tax because it ought to be built into the business model. Mm-hmm. Your description, what this is a great University of Alaska course on business planning and business development before you start your business, not afterwards. And so if you're going to go to the legislature and say you need to change our tax structure, two things are going to happen. One is legislators are not going to want to see less taxes collected because there's a constituency now built up. As you've heard from Health and Social Services and Corrections, there's people out there spending your money. Yep. Or spending tax money that you're paying in. So I would just caution you two things. One is look at the fishing industry. Talk to those folks, they have done a lot of work in terms of taxes and what benefit they get from that, from Department of Fish and Game, from the troopers, from enforcement, through the Seafood Marketing Institute. They have worked really hard to figure out how to tax themselves and how to set that level with the legislature so that they get some benefit back to them as a group. You're going to need to develop that. You go through this presentation and a public testimony at the legislature, you won't get any place. Might be good privately as a lobbying tool, but you know, the thing that they want is to make sure that they're going to collect the same amount of money and that people are going to pay. When I, as a local government official in Juneau, and a business is delinquent on their sales tax, they say, I can't afford to pay the tax. I remind them that their business plan says they're going to sell their product for $100. The city says you're going to add 5% to that and collect it for us and give it to us. And if they say they can't make money if they pay us the 5%, they're doing it wrong, because they're supposed to make all their money first 100. That 5% comes to the city, and all they are is a conduit to collect it and send it. And so I think that's the mentality you will find at the legislature. So you've got to come up with a way in which you're going to say, we can collect as much or more. This will be more beneficial to us. But if you don't come in collectively and you get, like the fishing industry, your group's fighting each other. You don't want manufacturers and cultivators and retailers fighting each other over who's going to collect the tax that's going to go to the state. So I appreciate all the work. I think this is good, but you've got to get your message down a whole lot different.
Well, and we don't have a message yet.
Well,
and that's kind of the point of starting this conversation was, hey, out there, everybody, industry, we have a problem. You know, in the licensing report, there's only 105 licensees out of 323 that actually have filed their renewals as of June 25th. And I don't know if that number's changed much, but in Oregon and Washington, we saw 1/3 of the businesses not renew. In a lot of these states, they started off like us with a flat, static tax. They get the bill passed, put 2 years in when we knew the prices were going to be high before it commoditized, right? But now it's commoditizing and it's a race to the bottom. And so we want to be, we've done so many things in this state for marijuana legalization that was so much smarter than a lot of other states. We avoided a lot of problems that other states had. I want to avoid this one too. So I appreciate all your comments, and I know that's absolutely correct. And we don't have our message down yet because This is the first stab at an idea. But I would like to ask Mr. Jones a question. As a local government, how do you feel about a retail tax? Does that seem like it's kind of infringing on localities' right to sales tax?
In several areas, the state does not have, quote, a sales tax. That's generally what you talk about, a retail tax. And they have, through Title 29, sort of given that authority to the cities. In addition, if you look at the tax structure for tobacco, they do allow local municipalities to put on an excise tax. City Borough of Juneau charges $2 or $3 a pack of cigarettes. On top of whatever the price is, we charge $3 as an excise tax that comes to the city borough. Most cities don't want to see that infringed on. In fact, most of us are looking, given the governor's actions on the budget, of having to raise more of those to cover costs that are being cut that the state's not going to share with us. So it would be very hard for the state to say, we're going to collect it to retail. Alcohol, tobacco is a wholesale tax collected basically at the cultivator level, well, at the distributor level. And then we collect a sales tax on top of that. So, you need to sort of stick with the state. And that's why I think revenue would be really reluctant to do sort of like a local retail tax, because instead of seeing 100 cultivators or auditing 20 cultivators or 5 distributors for alcohol, they would have to audit retail. And the last thing you want to do is say, put in this tax structure and revenue is going to come in and say, we need to hire 10 people to go out to all these revenue spots and audit them.
Yep.
You don't want that to happen.
No, and just so the industry understands, Department of Revenue ran some preliminary numbers on 2018, and for us to collect as much taxes on the 2018 numbers that we actually did, if we utilized the retail sales tax, it would have been just under 15% of the retail sales tax. So that would have been pretty difficult for a lot of.
And most communities that have put it at 8%.
Exactly.
Fairbanks, Anchorage,
Yeah.
you know.
So that would have been very difficult. So that's good feedback.
Okay, thank you, Ms. Wilson, we really appreciate it.
Thank you.
And this is the sort of thing, this is the sort of issue that you can talk to Mr. Jones or anybody else with on the side, because we don't have anything to do with it, so it's certainly you can have all the free-range conversations with, any of us about this you want.
Okay, thank you, and I just wanted to add one more thing. The other thing that should be on the industry's mind is the statute for imposing the taxes. It only allows the Department of Revenue to levy taxes against licensed operators. It does not allow the Department of Revenue to levy taxes against black market actors. So that's maybe a little bit of a legislative fix that we can use as a tool.
Okay, and that's, again, yeah, and anything that's in statute for anybody, it's got to get dealt with by the legislature.
Yeah.
Okay, thank you very much. Let's move along now. I was looking at that picture, and actually, I think I'm the only one that was at the only one on the board who was at the very first meeting. I don't think you were there.
I was in China.
You were in China.
I made
the back wall. I'm waiting on it.
I made number 2.
Well, okay, all right. Well, the thing, what my point was that there was somebody who kept showing up to these meetings. I kept looking out there, and I said, "Oh, that's Mr. Natural." And it took me, I don't know how many meetings to figure out who Jim was. So, Jim Dwyer, this is, and Kelly, if you want to call them too, this is an invited presentation, again, kind of education for both our new member, we were hoping to be mentors. But Jim's business is, he's not a licensee, and as far as I know, he doesn't have any interest in licenses, but you just got to talk, it's got to talk, yeah. But what he does, as he will explain, is really, really, really important both to the job we do, the job enforcement does, and to the industry. So, Jim, go right ahead.
Thank you, Mark, and thank you to the board. I appreciate the opportunity to come and present. So I'm Jim Dyer, D-Y-E-R. I live and work in Anchorage. My wife Kelly, and I own a business. It's an ancillary business which provides packaging and labeling and certain accessories to the licensees. Our customers are cultivators, manufacturers, and retailers primarily. And so what we do is we print labels, and we either provide those labels directly to the customers, and then they put them on containers. Or more often, what we do is we put the labels onto the containers, and what we deliver to the customers are labeled empty containers. We are not licensed to handle marijuana, so that's what we do. And so we're kind of like the packaging nerds. We deal with a lot of numbers and whatnot, and certain packaging technology. As of April the 12th of this year, we had printed 4 million labels for this industry, and I think we're probably somewhere around 4.3 or so now. Seems to be accelerating as we go along. So what I want to talk about, and by the way, I should point out that this presentation is a slightly modified and improved version of my presentation, so I've emailed it to Erica last night. You may not have seen it yet. And he has a copy on the flash drive. So
what is showing here is a little bit different than what's in the tab on your computer.
Oh, precisely, yes. What I want to talk about is best practices for packaging and labeling of marijuana. And you see on the slide a list of things which I believe are common sense. On the other hand, people don't necessarily get it at first. Many of the licensees have never worked in a regulated industry prior to this, so some of these concepts are new to them. But best practices would include knowing the regulations, complying with both state and federal regulations for packaging and labeling, adhering to a conservative interpretation of regulations rather than trying to push the boundaries is often the best choice. Providing end-user warnings, especially on edible packaging, and licensees should show regulators that they're doing their diligence in this regard. If uncertain, they should ask AMCO enforcement for some guidance, and above all, as well as complying with the regulations, the packaging and the labeling should protect consumers. So, I was thinking of something I wanted to say there. So what I have here on this slide is a listing of both state and federal regulations that are applicable. Of course, we have the statutes and regulations for marijuana in Alaska, and that's enforced in Alaska by AMCO and AMCO's enforcement arm, Marijuana Control Board as well. And then on a federal level, there are several aspects to this. Marijuana is actually a consumer product. So with that in mind, the regulation for consumer products on a federal level, they occur in several different documents, but one that pretty much covers everything is the National Institute of Standards and Technology Handbook 130. And in this particular chapter 4A, we have the Uniform Packaging and Labeling Regulations. This is actually enforced by a state agency under DOT, the Measurement Standards Department, formerly known as the Department of Weights and Measures. Any marijuana product that could be consumed orally then falls under the FDA guidelines and regulations. And you see the documents there mentioned. Actually, the FDA regulations are like huge. And you can find them online under the Code of Federal Regulations, Title 21, Food and Drugs, Part 101. And the nice thing about these regulations is everything that's written in the Consumer Products Regulations and the Food and Drugs Administration Regulations meshes together quite nicely. And we've never really found anything that is not in alignment. So that's been it's been easier for us and everyone concerned. Child resistance on a federal level, there's another CFR. It's in Title 16, Part 1700, poison prevention packaging, and that's where the definition for child-resistant packaging lies, and also the definition for how packaging is certified as child-resistant. So, child-resistant packaging, I was unable to find anybody else at the state who actually enforces child-resistant packaging besides AMCO. Maybe that search needs to continue, but I talked to quite a few departments. On a federal level, I think until 1973 or thereabouts, the FDA actually enforced child-resistant packaging regulations, but after that, Consumer Product Safety Commission took up the reign on that. So, next slide, please. So, what I want to talk about now is this listing here, listing of required information on commercial package labels for marijuana. And what we have here is the requirements based on all the regulations that I just talked about in the previous slide. So a lot of this we're all very familiar with, cultivator or manufacturer name and license number, retailer name, that is the retailer that's going to sell that marijuana that's in that package with that label. All of that's required. The total estimated THC, health and safety warnings, the 5 warnings that are always on the packages. Harvest batch or production lot numbers, those are always required. Harvest batch for flower or pre-rolls. The production lot numbers for concentrates or edibles. So these next 3, the declaration of quantity, which is actually the same as the net weight, the declaration of identity, and the declaration of responsibility, those all come from that NIST handbook for consumer packaging. Those are required for all of the products. quantitative statement. In other words, if you have a package that contains 3 pre-rolls, for example, there would be a statement on the package saying that it's a 3-pack. Same thing applies to, let's say, a package of cookies that has 5 cookies in it, then it's going to say 5 servings on the package. The metric numbers, so this may be interesting for everyone. The metric numbers are required absolutely if the packages contain contents from a combination of different harvest batches or a combination of different production lots. And this happens sometimes when, say, a cultivator or a manufacturer has sold most of a harvest or a production lot, but there's some remaining, and then they've got that remaining piece from several different ones. Then absolutely a metric number has to be assigned. It's a special metric number to identify that unique combination of batches or lots. In other scenarios where those harvest batches or production lots are not being combined, a harvest batch number or a production lot number can suffice as the tracking number. And here's how this all came about was that, let's say a cultivator is ordering packaging and labeling. They don't yet have a manifest for the delivery to the retailer. So they don't yet have the metric number that is specific to that delivery. And that delivery defines that package, let us say, of multiple packages that's being purchased by the retailer for sale to consumers. So in that case, we needed another solution, and we worked with enforcement to come up with the traceability of the harvest batch number or the production lot number to suffice as a tracking number. So that's the practice today. This is just the sort of thing that I would like to see a continuing dialogue about. And if possible, maybe at some point you guys might decide to start a committee or something on packaging and labeling, and we could start to really explore a lot of this stuff.
Yeah, Jim, I was gonna ask you on some of this information that goes on a package, and you don't even need the answer. Would any of it, maybe it's something to talk to enforcement about, could any of it be barcoded to save space? Some of it's information that the consumer, if the consumer needs to know it for some reason, it can be found out with a quick swipe. But you know, stuff like maybe metric numbers of contents could be barcoded on there, be perfectly readable, you know, electronically. But and possibly, I don't know whether NIST has any allowance for that in their requirements. So I just want to toss that out there because I know that sometimes we get small packages, you know, small labels, and then you need magnifying glass to read some of them. So I just want to throw that out there for you. So
well, I can give you part of the answer. What I can say is that we do barcode, QR codes at request of our customers, and it's usually for retail SKU, which is their inventory tracking for the retail. It's certainly something that we could explore further, you know, to say encapsulate multiple pieces of information in one kind of a readable code. So that's a possibility, which would be just the sort of thing I'd like to explore, you know. So we also always put a pesticide, herbicide, and fungicide statement on packages. And by the way that we get all the information that we put on labels is we have a thing, an order form that we have customers fill out, and we call it a delivery batch kit order form, a DBK order form. And on that form, there's a question. Were any pesticides, herbicides, or fungicides used in the growing of this product or the production of this product? So it's like the honor system. These things aren't tested for by the test labs, but what we do is we ask for the answer, yes or no. If the answer is yes, then we ask that the specific products that were used be listed, and then we include that on the label. There's been some talk in the industry that it might be better just to say not tested, you know. But on the other hand, people who have I can't use the word organic, but people who have used processes where they did not use pesticides, fungicides, and herbicides, they want to be able to say that. So that's the rub on that. So, like I said, the way our process works is we ask the question, we get a yes or no, then that determines what we put on the label. We also put a residual solvent statement on labels for concentrates, and that's a pass or fail. If it fails, then there's no package to talk about. So, but it needs to be stated on the label. Ingredients list, nutrition facts, and expiration date. By the way, I do have a bunch of examples of packaging here with me, and I'll be available during breaks and whatnot, and I can pass these around for you guys to look at in detail. But the ingredients list, the nutrition facts, and the expiration date are just the same kind of thing you find on commercial consumable product, and we follow the same regulations for that from the FDA. There's one more thing there on that same line. You might see sort of a gray X under concentrates. So what I'm referring to there is that for concentrates, sometimes a complex concentrate like moon rocks would have an ingredients list for the flower or the bud, the keef, the cannabis oil that was used to make that complex concentrate. That's a different type of ingredients list. Next slide, please. So what we just talked about were the items that are required for labels on commercial packages. This is here a list of optional information that's frequently desired, but it's not actually required. Cultivators like to put the strain name. I don't think we've made a package without the strain name on it. And strain name is not a scientific thing. It's a historical thing in some cases, or in some cases a very short history that they just made it up that day and then it goes on the label. It's magical things like Blue Dream, Sour Diesel, OG Kush, Green Crack. Species is also very frequently identified on the label, and that would be indica, sativa. I don't know if we've ever made a ruderalis. We might have had a couple. Or a hybrid of indica and sativa, or indica dominant hybrid, that sort of thing. The cannabinoid profile, as I mentioned earlier, it's always required to put the total estimated THC on the label. The other cannabinoids that are listed there are the 5 that are required to be tested for by the test lab, and it's very normal, very consistent that we would put all of those on there and the percentages. Terpene profile, the terpene testing is optional for the licensee, and they have to pay extra to get it done, but it's pretty popular to do that, and if the results are good, they like to include some of the highest percentage terpenes on the label. Retail SKU, as I mentioned earlier, we can certainly do that, and we do for a number of our customers. Some people like to put their website link, URL, and or their email address on the package. So that's another optional thing. And there's other things too, but these are this is just a list of the most popular optional information that go onto the labels. Next one, please. There are some restrictions on the packaging and labeling. As I mentioned earlier, organic cannot be put onto a package label. People sometimes come up with some pretty interesting ways to imply that the products are organic. But that terminology and that designation is controlled by the U.S. Department of Agriculture, so we don't go there. Printed images, including cartoon characters targeting persons under 21, is not allowed. It's specifically mentioned for flower and bud, and the same thing as well as bright colors and products that look like candy for marijuana products. Even though some of them are candy, they're not supposed to look like candy in that special way, so it's not allowed. And again, here's a reminder at the bottom: the best practice is know the regulations. go with a conservative interpretation and show regulators that you're doing your diligence. And that's what we try to impart to our customers, you know, let's stay on the right side of things here. Next slide. So, we had a little bit of discussion, I know Mark and Erica and myself, about what other states are doing, and I can speak to that to some extent. You see there listed 4 other states where they require icons, a specific icon on the package, and you see them there on the slide. There's a number of interesting things that are going on in other states where they have more funding and resources and that sort of thing. Some states are publishing FAQ lists on the web, things like packaging and labeling and other aspects of the licensees, you know, business, how they conduct their business. Some of the other states are putting out pamphlets online, or, you know, kind of like an online brochure, just hitting the highlights of do's and don'ts, that sort of thing. So, kind of like easy, quick guide sort of information. If it ever comes to pass that you all decide to go there, I'd be very interested in participating in that. Next slide, please. So, this slide's very unscientific, but it's also pretty interesting, about packaging materials and some aspects, recyclability, cost, biodegradability, utility, between different packaging materials like paper, plastic, glass, metal, and bioplastics. So, based on our knowledge and our experience, what we're seeing with recyclability is most types of paper are really easy to recycle. And, you know, you can just put it in your bin and at the curb and they pick it up and there it goes, kind of thing. Plastics, many plastics are relatively easy to recycle, and you see the symbols on the plastic to tell if it's a category 1, 2, 3, and it goes on ad infinitum. The most commonly occurring petrochemical plastic in the cannabis industry is polypropylene, and it's category 5. There's only one place that I'm personally aware of specifically that recycles polypropylene number 5 in Alaska, and that's Valley Community Solutions for Recycling in Palmer, Alaska. And they do recycle number 5, and we send them, we drive up there a couple of times a month with loads of polypropylene, and we feel a huge responsibility because we, in our business, we're putting loads and loads of that polypropylene out into the world. And so it's a concern. And as such, what we've done this year is we've started to actually, my wife Kelly works directly with factories in Taiwan and China, and we've designed some paper packaging that we're actually already delivering to customers. And one of them is like this. And this is a paper package that's also child resistant and has tabs.
And that's compliant, child resistance.
I would say it's compliant. It's not certified, but it's certifiable in my estimation. So these tabs, you have to manipulate the tabs to allow the box to open, and it's kind of a drawer configuration. And it can have different inserts inside for different products. Could be any type. We're also working on a paper J-tube, which is for pre-rolls. And what this is a reduction in plastic. Instead of a number 5 polypropylene J-tube, which is, by the way, child resistant and restorable to child resistant status. This here is a paper J-tube that has a plastic cap. And this cap is intended to be child resistant as well. This is a prototype. and we're hoping to deliver this to the market sometime in August or September. So anyway, I think that there's a huge demand for eco-friendly packaging in our industry, and we're hoping to get more into that. So you can kind of see how I've scored different materials here. The problem with plastic is it just works so well, and it's the lowest cost material as a general rule. It could be argued in some cases with different types of packaging and so on, but plastic is quite cheap, and as you see on the utility score, it's also got a pretty high score, and that's because of it. You can do things like this. You know, it's got that springiness and flexibility. Biodegradability, the paper seems to win. So anyway, this is, as I said, it's an unscientific kind of a slide, but I think it's reflecting what I believe to be the truth is regarding the materials. Bioplastics is an area that's going to grow, and it's going to become, currently it's very difficult to recycle because there's not a lot of recycling services that deal with it. But I think that's going to change over time, and it's going to become more popular. And that's definitely a reduction in petrochemical plastics. Next slide, please. So just a bit on child-resistant packaging. I'll try to move quickly here. Our state of Alaska requirements for the packaging that a consumer leaves a retail store with and they exit the store, we require it to be child-resistant, opaque, and resealable. So you see the vertical black line there in the slide. Everything on the left side of that line, those are containers or bags, vials they're resealable, and when they're resealed, they're in a child-resistant state. Okay. Over on the right side of that vertical line, we have bags. These are Mylar type bags that they meet the SOA requirements as long as they are either, number one, opaque on both sides and heat sealed, or heat sealed, and let's say it's a transparent bag, and for number two there, as long as it's heat sealed and placed inside an outer bag which is opaque. And that comes from a Marijuana Control Board meeting that was in April of 2017, where that ruling was made. Not actually in the regs, but I believe it to be, that's the way things are. So anyway, this is just a bit on the child-resistant packages. Next slide, please. If we were to, give customers, and this is a presentation that I sometimes give to customers and people wanting to know more about packaging. These are considerations for selecting packaging for specific products, and you can read the list here. I think regulatory compliance and safety is at the top of the list, and then commercial concerns like displaying and selling the product, branding, marketing position, maintaining freshness of the product is a big thing for marijuana. The packaging should not be toxic or damaging to the product, and if you want to save some money, do the child resistance on the initial package. Don't go with a secondary package like I showed whenever possible, because you're spending twice here, okay? On the other hand, sometimes that's just the solution because of the type of packaging that's the primary package. Physical dimensions are important, it's common sense, but we're talking about ordering thousands, in many cases, of packages for a particular product, and so let's measure twice and order once. Cost and environmental impact. So there you have it. Thank you very much. As I said, I'd be interested in continuing the conversation.
Great. Anybody got any questions for Jim? Okay. I really appreciate your taking the invitation and coming and present this to us. I learned some stuff. I had the opportunity to in Meeting Anchorage. You and Kelly hosted a couple of us over there at your shop, and it's really a state-of-the-art facility.
You know, Alaska manufacturer, right there, you know. So, thank you very much.
Thank you, Mark. I just would mention that we employ 18 people, full-time, in our business, and we're proud of that.
Yep. All right, so which brings us to the director's report. Go ahead and take your time. She's not feeling too good. She's sick, get back from vacation. I don't understand how that works, but it happens.
Thank you, Mr. Chair. As I have mentioned in my written report, we will shortly be conducting interviews to fill the regulations specialist position, and I hope to have the program coordinator position filled by the end of the summer. These two of our 3 vacant positions currently at AMCO, and Chief Holscher will mention a vacant investigator position. There are 2 issues to particularly mention to you. One relates to renewal applications. At 3 AAC 306035A, the regulations state any establishment active and operating on or before June 30th of the current year must submit the completed renewal application electronically along with the license renewal fee to the director not later than June 30th of each year. June 30th is on a weekend, then it's 4:30 p.m. on the following Monday. So I read this to mean that all renewal application documents must be received by the deadline, but there is the argument that this could mean postmarked by the deadline. So I would ask the board to either concur with my interpretation or direct us differently.
Okay, and it's kind of customary when something comes up, we take it right up. So is there any thoughts on this? It's how many licensees has this posed a problem for, just anecdotally?
I'm only aware of a handful, 2, 3. And just to remind you, we do send out the renewal notifications 2 months in advance, so there's plenty of time for people to get this done.
Yeah, I don't know. I think I would just say I don't think we've heard any public testimony, or maybe we have. Maybe one time there was a little bit of discussion about renewal, but I think on something like this, in order to treat all the licensees fairly, we should just stick to a fairly strict interpretation of what it says. And it has to be in the office by the deadline. Anybody else got any thoughts on that?
So, Mr. Chair, what is a strict interpretation in your view? Submit legitimately can be, in some circumstances, does mean postmarked. So if you interpret this to mean it must be received by, then I would strongly suggest that you make that clear to the public and at some point fold this into a regulations project to amend it.
I agree. I think there are a lot of, I go back to voting, which voting by mail is a postmark. They allow a legitimate time. I think for overseas it's like 10 days before it's delivered. And I sort of broke this down in my mind twofold. One is, if all of our filing is electronic, there's no reason for it not to have been received, by the close of business that day. If you're talking about, you also have to receive the licensing fee, and that is cash that has to be mailed or cash that has to be brought in, or however they're going to present a check. That's generally not done electronically. And so if I was delinquent and sloth like I tend to be, and on June 30 at noon I was filling out the electronic form, I probably wouldn't mail the check till that day, and so you would easily not get the check. So I sort of broke those things down twice. If you had the actual application, then there ought to be 5 days you should have the check, or 6 days or something like that, because unless we have eventually through banking we have the ability for electronic transfer of funds, So I sort of, in my mind, broke this down, but I wasn't going to. And I think Ms. Milks has the approach. If we're going to split those two, we need to come up with some regulation and not put the burden on staff to do the interpretation that 6 days after June 30, your check's not here, you're done, 7 days and we can't take it. So I think we need to work on that. So, but I think if they have the actual paperwork filed electronically, within a reasonable time, and that would be up for the debate on when the check will be received, because you basically don't have the ability to do payment at the same time you file your paperwork, because we can't do it electronically. So that was my thinking as I read this.
You might want to see what the practice is with other departments, professional licensing and commercial fisheries, energy commission, places where there's a permit that is, economically valuable to and if they were to miss a deadline, they would be, out of work. So maybe you just take a glance around and see how other departments do it, so that maybe we can be uniform.
Well, so the deadline here relates to when a late fee is assessed. So it's not like, oh, boom, the license is gone. It's that, oh, now you're late and you have to pay the late fee. I'd be happy to look around, but I'm going to assume that these other programs are governed by whatever their regulations or statutes say. So, if you'd like, we can take a postmark, we can interpret this as postmarked. Submit means postmarked. I do agree that it should be clarified in regulation. And as you know, I think we talked last meeting about an issue with what does the word application mean in the regulations. Sometimes an application really just means the public notice. Talking about posting an application in the grocery store near your location, we're not talking about posting 100 pages that includes all of your, all of your MJ02 and 04 and whatever. We're talking about posting the public notice.
Maybe the word application doesn't even need to be in there.
I think it means different things in different places, and I think that needs to be cleaned up. So perhaps this can be sort of wrapped into that.
Okay, well, is there a motion to open a regulations project on 3AC 306-035A?
I would so move.
A second?
I'll second.
Okay, Mr. Jaime.
Mr. Chair, may we expand that to address the concept of the word application, to correct or to clarify what we mean by the word application in various elements of the regulations?
Think you got a...
Sure.
Okay. All right. Okay, so yeah.
Seconded.
It's got
Mr.
second.
Jaime.
Okay, any discussion? All those in favor of the motion signify by saying aye.
Aye.
Opposed? Okay.
Thank you.
Yes, ma'am.
So the next issue, you may recall at the last board meeting, there was discussions of what a recreational or youth center means, and Mr. Jones had specifically asked for sort of a history from the minutes of how the board has looked at this term. So what I have done here is provided excerpts from the minutes, including also from a packet in one situation of how this issue has come before the board at various times. I think you may actually have asked me to put a time to discuss this on the agenda, and I didn't manage to do that, and I apologize. So my recommendation to the board had been to address this through a regulation. You do not have a current open regulations project on this definition. As you recall, and as reflected here in this outline, you had opened a project on this before, and it died. It did not end up moving forward, but it continues to be, it continues to cause conflicts, a lack of clarity on what exactly is a recreational or youth center. So I would encourage the board to work on this.
Okay, any discussion on this issue here? Any ideas?
Mr. Chair, I think we need to, I think we need to take a look at the, distances, what we have in the, I guess it's in that first section. When we have distances between churches, we have distances between recreational, treatment facilities. We have, I think there was one comment someplace I read where, you know, do we mean, you know, by signage 1,000 feet from a school? We have one application in here that I remember reading, that talked about, that they were 60 feet from the school property. But, and our regulations read to the property line for a school. It reads to the front door of a church. It reads to, and the property line in this case was, you know, a couple thousand feet from the actual school. You know, we had the one in Fairbanks here where we argued about whether it was part of Tanana Chiefs and treatment center and how many acres that involved. I think this is an important definition. It's important to get that in there, but it may be one that we would want to look at better defining what we actually mean. And I say that for twofold. One is it would give some direction to a local community if they so choose to address that. We've struggled with that in Juneau about whether that in our conditional use process through the Planning Commission, whether it's their responsibility to go out and measure or whether it's AMCO's responsibility to measure, the responsibility of the local to enforce a state regulation on distances where we don't have that same restrictions in any of our ordinances. So I think it is a worthwhile project. I think it needs to be one that maybe looks just beyond this definition because, and gets clearer so that both staff and us, as we're reviewing applications like we will later, can make some clarity on that. And that's a very long-winded say, though. I would like to open a regulation
I was waiting for that.
related to the definition of recreational youth facilities and distances to those building services or activities that we restrict licensees. And that's a poorly worded, but I think you get what I intend.
Yeah. That motion makes sense?
Yes, it's not seconded. Maybe we can get seconded before I can make a comment.
You got the intent there, sure. Is there a second for that motion?
I'll second it. Number one, I think it needs more definition. I've struggled with this for a long time as well. And I would like to be a part of the committee as well. So.
And that was what I was going to ask. I understand that there, and agree with Mr. Jones that there does need to be work and clarification, but I don't have a sense of what direction the board would like us to go. So perhaps if there could be a subcommittee to work with the staff on this, that'd be great.
And we should both be on that subcommittee because I'm assuming we're going to go that way.
We're probably at opposite ends of how liberal we want to be and how conservative we want to be.
Plenty in here we can blame on the two of you.
Perfect.
Okay, yeah, I think that's good. You know, I was just thinking while you were talking, we're still in the process of tuning these up, and hopefully when we get done, these regulations will be good for the next 20 years or so. You know, looking at the alcohol regulations as a corollary. They've been around since territory days, so. Okay, any other discussion on the motion to open regulations project to consider definitions of youth center
and separation distances.
Okay, all those in favor of open regulations project, signify by saying aye.
Aye.
Any opposed? Right, the regulations project is open. Moving right along.
Thank you. At the last meeting, you reinstated an approval for license 10071 Vern's Wicked Weed and required a report that an inspection had been completed by the July meeting. As of July 7th, no inspection has been performed, but I do know that the licensee, Jeremy Erickson, had an issue getting credentialed into Metric. That was really because of how the staff had worked on his dates in his license. So that's been resolved just today. So I don't know what you want to. Well, I can't swear that either. But it should be soon, I would think.
He's not Anchorage, right? Or was he?
I don't think he's Anchorage.
Yeah, I can't.
And I also, because I just was, it was while going through the minutes that I noticed that the board had asked for this. I don't think he's aware that he's mentioned. He's in Sitka.
Oh, Sitka, all right. Okay. Thoughts, I was gonna look at the last agendas. The Rule 71. Let's see. Where did he show up in the agenda? Was it in the director's report last time too?
No, it was,
He wasn't an applicant.
he was, I think he was either under board consideration or, let's see. He was tab 39 on the last agenda.
Well, you know, it's Sitka.
I can bring a report.
So he said he was on the phone with us in February. Let's see if he's on the phone by any chance, real quick.
The conference is no longer in listen-only mode.
Marijuana Control Board, Jeremy Erickson, Vern's Wicked Weed, are you on the phone with us?
We're done.
Jeremy Erickson. Going once, going twice. Guess you're not there.
The conference is now in listen-only mode.
He said he would request final inspection within 30 days.
Mr. Chair?
Yeah.
I would move that we extend that date to September 1. We could probably do a teleconference meeting rather than wait till NOM. This would give him a month and a half, and then we can act, I think, go a little extra mile on a couple of these. But I would suggest September 1, and if there's any thing we need to do, we could schedule a meeting before that.
Yeah, sounds good. There's a second?
Second.
Okay, and again, this is kind of standard practice. We try to facilitate commerce as best we can. All right, all those in favor of the motion to extend the deadline for receiving a report that an inspection has been accomplished for license 10071 until September 1st, say aye. Aye. Opposed? Okay.
Thank you. I have attached a regulations project status spreadsheet as usual. I do note that we're a little behind on getting you drafts of new projects. The spring with the legislative session makes things extra busy, so I'm hoping to catch up and have most of these, if not all of them, prepared for your consideration at the September meeting. The September meeting is scheduled for September 11th through 13th in Nome. It's going to be at a brand new location there, so that'll be fun. And applications must be complete, and any other documents for the board must be submitted to our office by August 23rd in order to be on the agenda and included in the board packets. I've included your usual statistics and would be happy to answer any questions.
Okay, any questions for the director about her report?
I just want to make sure we're clarified. So we're saying for the applications renewals, so anyone who submitted by June 30th and anyone who was postmarked by June 30th will not be assessed a late fee.
That's what I heard.
I just want to make sure, because in typical form, I don't think we were real clear. And I just want to
very
make sure
typical.
we were very clear on what we said.
And actually, because June 30th was
It'll be July
a Sunday, it's postmarked by July 1st.
Yeah. Okay.
So
this year.
I think it's important for this, and in line with the report here. I think it's important for us as a board to recognize the very hard work that you put in doing your job, running a pretty large staff with some very multifaceted duties. And anybody that's familiar with the job that she does knows that she works more hours than I'd ever want to. So I want to personally thank you for the job that you're doing. And I would certainly, as the chair, somebody would like to make a motion just recognizing the fact that we appreciate the job she's doing, that we have got full confidence in the job she's performing. The chair would entertain that motion.
So moved.
There's a second.
Second.
All right, so that's what we think, I think. So all those in favor of the motion to express our confidence in the job that the director is doing for us and for the people of the state of Alaska and for the industry, signify by saying aye.
Aye.
Any opposed? Don't hear any? Okay, very good.
Thank you.
Director.
Thank you very much. Your support means a lot to me, and I really appreciate it.
All right, you bet. Okay, I'm sorry, yes, the data agreement. Yes,
There's one more thing to
Yes.
deal with under the director briefing. Jessica Philly is here. If you want to step forward.
Cool. Come on up.
She is with the Department of Health and Human Services, and we had worked with Jessica and Eliza Muse to develop a draft data use agreement last meeting, and the board had some concerns, so we've made some revisions to bring before the board that we hope will allay your concerns. I do want to note that, the Department of Revenue has access to metric data, so it's not, we're not forging new ground here by allowing another state department to have access to metric data. We've tried to be very clear that the access would be read-only, so there would be no ability for Jessica, who is the identified sole individual at the Department of Health and Human Services who would have access to this data. There would be no ability for her to accidentally make any changes to the data. And Jessica and Eliza have provided an example report. It uses Washington data, but it's an example of the types of reports that they would be looking to produce that could be used by the board to help inform your decisions. And to that matter, it was suggested that in the very first paragraph that the wording of the, I think, third sentence, where it says DHSS analysis and reporting of data will inform the Marijuana Control Board, providing information used in the board's decision, maybe make that a little bit more, providing information that may be used in the decision, because, you guys can use whatever information that you see fit.
So Jessica, go ahead and introduce yourself to us.
All right, cool. Kind of wrote down some thoughts because hopefully make sure I say everything that I'm going to say, but so I'm an epidemiologist.
Well, just identify yourself.
Oh, sorry, yes, I'm Jessica Philly. I'm an epidemiologist with.
How do you spell that?
Filley. Yeah. And I'm with the Office of Substance Misuse Addiction Prevention with DHSS. And yes, I'm here to answer questions that you have, give you 3 minutes or how we're looking to use the data, and just also to give put a face to the to the names so that you guys know. If you can be around, you can ask questions. So just some quick background on me as well. I'm a subject matter expert on opioids and other substances for the state. I've worked with many large data sets, authored health impact reports on opioids and marijuana, and developed state data dashboards built for multiple data systems across the state. And part of my job is to establish these data use agreements and to ensure they're followed. So I've worked with vital records data, medical marijuana registry data, poison control data, among others. And I understand the importance of strong and clear relationships around data sharing. I want to stress that to you guys as well. So in the establishment of this data agreement and discussions with AMCO, really thought there could be a mutual benefit to having read-only access to metric, as it is a rich data source that could inform both our public health efforts around prevention and programming, and to help you make more informed decisions moving forward as well. And so With this data use agreement, we made sure to address concerns regarding privacy and confidentiality. I will be the only accessor of the data and will follow standard data suppression protocols and aggregation to ensure the confidentiality of retailers. My level of access will ensure that data cannot be changed or manipulated, as Erica said, within the system. And no linking of data to other data sets will be performed without prior authorization. And finally, I think it's important to note that all public release of data will first go to the director for her review and approval. So an additional thing to mention is that Metric is built on the SQL language, and I'm experienced with SQL code, so we've talked about me offering this expertise to AMCO so that they can, we can pull more complicated reports beyond the standard reports that Metric has. They're very standard, so it'd be interesting to pull those all together. So I'm willing to do that for any inquiries AMCO may have, as AMCO currently doesn't have full capacity to do this with their staff. So Erica also mentioned that we have the appendix with the examples of different graphs and charts that we could put together. So currently our specific interests for data include looking at total cannabis sales by product type, which I think would be also useful for all of you to know as well. And we want to map the number of licensees over time, and also monitor price per gram over time. And then, you know, as things come up in the future, we can talk about those as well. So, if you guys have any questions or concerns.
We had a chance to go over. Go ahead.
Yeah. How far down do you plan on aggregating data? Is it going to be by borough? Is it going to be by municipality?
Well, so it would depend on, we have this kind of a general rule that less than 6, we won't really report, so then you can't identify, you know, exactly which retailer it would be. If there's one in, you know, one small borough, we're not going to talk about that data because you could obviously identify who that was.
So it'd be by borough, not by city?
Yeah, it would depend. Like it could go all the way out to public health.
Well, you could do the unorganized borough as one unit, right?
Yeah, there are different, you can do all.
Which would be good, because then we can see.
Well, that was I just wanted to be cautious that we're going by city. Some cities only have one.
Yeah, we don't have 6 definitely.
And I think that they haven't made a decision exactly what type of unit they'll be looking at.
Yeah.
But if there's ever a situation where there are 6 or fewer retail stores in that particular unit, then it won't be reported on.
Okay.
Or we can go look bigger, you know, look at public health
Right.
research.
Yeah.
There's more in the
All right.
Hey, if there's anybody you can trust with your data, it's an epidemiologist.
I hope so.
Any other questions, comments? This agreement look okay to everybody?
Mike, yeah, I think this is better than the last one. Hopefully the attorneys for both agencies have reviewed this, but, and in terms of what I've seen from public health over the last 30 years with like the youth risk behavior surveys, the school-based surveys, they're really good about, having that information in such a form that you can't say it's the Kotzebue schools or the Nome schools or the Bethel schools or the Juneau middle school down the street. It's pretty well aggregated to the point where it's hard. Although on those there are some individual school reports that are available to the schools, but not what gets made public. I don't know that any of that would be necessarily here. I hopefully their process will have some validation so that if they produce a
Welcome to the GCI Conference Center. Please enter. Thank you. Please stand by. You are being placed into conference in listen-only mode. There are 47 participants in the conference.
We assume that things are disclosable because all of this is the public property, but we would look at other concerns and see whether the state's interests outweigh any potential disclosure of any private information, that kind of thing. So I can't tell you in every single case that it would be disclosable, but I would say probably.
Okay, and I'm just thinking about the granularity and whether somebody can come in and say, well, I want to know what the source data was for Anchorage and get, the name, be able to dial down. And we might have to reveal the names of, how much product Nick sold on Wednesday.
Right, and I doubt that would
Okay.
happen because agencies are not required to produce data in a particular form. So if you don't have that source data on hand, you're not required by the Public Records Act to produce it for the requester. But to be perfectly frank, I really haven't looked at this agreement very carefully, so I can't tell you for sure. But my bet would be against disclosure of source data.
Okay, very good. And Mayel and Erica made a good point where it says that the data in the first paragraph, let me get back up there, will inform the Marijuana Control Board. I myself at least think it might be better to add the word "be available" before "to inform."
Okay.
And I think that would cover everything. That means, we can do what we want with it. And it says "will," then I don't want to
be informed.
I don't want to get into dueling departments. All right, is there any more discussion on this? I'm really happy that you'll be able to sit down with our crew, and I think that eventually we'll start to come up with some requests for boiled down data. So thank you for being an expert, and appreciate the fact also that you're a subject matter expert on something that is totally unrelated to what we deal with, but on the other hand, there'd be plenty of people who say that it is. So as this gets developed, it'll certainly shed light in many directions. Cool. Okay, so is there a motion to approve the data use agreement?
Chair, if I may, before you make a motion to approve and take a vote on approving this, may I ask that you revisit this after lunch? Because I apologize, I haven't had a chance to really look at this
absolutely.
very carefully.
Yes. We can do that. So let's break for lunch, and we will take this up right away. See you at 1 o'clock.
The chairperson has disconnected. The conference will now end.